7 at facebook.com/1210WPHT.
WPHT, 3 Supreme Court cases before the justices today. They needed to rule on them before they hit the road. Joining us now is Byron Henry. He's a legal expert, also a Supreme Court expert, and an appellate partner at Scheef Stone. Byron, thanks for joining us here on WPHT, and thanks for hanging on. We appreciate that.
Glad to be with you, Matt.
I want to start with the big one, the Texas abortion access law, a victory to supporters of abortion rights. You are in Texas. These the supporters of abortion rights argued it would have shuttered all but a handful of clinics in the state. This was a 5-3 ruling, pretty significant, one of the most significant, I would say, in a couple of decades. What's the feeling like there in Texas? And from a legal perspective, were you surprised by this?
Well, I'm not sure I'm surprised by anything these days coming out of the Supreme Court, especially when it comes to abortion. And with only 8 justices, it's kind of been a crazy term. I can say that there's a little surprise down here in Texas, just from the standpoint that these laws did not directly infringe on any constitutional rights, let alone the judicially created right for a woman to obtain an abortion. What the law simply said is that abortion clinics needed to meet certain standards, and the doctors needed to have admitting privileges at nearby hospitals in case something went wrong with the procedure. If you remember this, this law was passed over 3 years ago, and that was during a time when the Kermit-Gosnell controversy and other issues regarding unregulated abortion clinics and abortion providers in other states were turning up basically some horror stories with respect to what had happened to women and some of the children that had been aborted, and some had survived and different things. So this law was basically to provide more oversight on abortion clinics and abortion providers. But instead of attempting to comply with the regulation, abortion advocates went directly to court and attempted to block them and basically said, we can't afford them, we shouldn't have to comply, this isn't going to help improve women's health in any way, shape, or form, and it's just a thinly veiled attempt to restrict a woman's access to abortion. And that was basically the way the two sides squared off in court.
Have they been successful then at calling this the so-called clinic shutdown law? I mean, that's clinic shutdown, that sounds negative to me, but it sounds like it's a successful legal argument.
Well, the problem here is it's a successful legal argument, and I think the dissent pointed this out today, that it's a successful legal argument because the court applies a different standard and different rules to abortion regulations and things that even remotely affect the right for a woman to have an abortion than they do in any other context. It's basically this abortion right has reached the zenith, is at the top of the mountain with respect to constitutional rights. And there are laws that restrict religious freedom, the right to bear arms, and free speech that don't get the scrutiny that these laws on abortion clinics receive today in the Supreme Court's majority opinion. So basically this serves notice to states that if you're going to pass a law that even tangentially affects a woman's right to terminate her pregnancy, you better have a very strong record and a very compelling reason and strong proof that it does something other than cause an inconvenience to women trying to have abortions. Otherwise, it's liable to get struck down.
Yeah. Our guest is Byron Henry, a legal expert, Supreme Court expert, and appellate partner at Scheef Stone. Brian, I wanted to get to the other 2 cases before the court today, but we're up against a break. If I could get you to hold on through the break, and we'll get to the Virginia Governor Bob McDonnell, the case against Virginia Governor Bob McDonnell, and the case having to do with guns and domestic violence.
Certainly.
Matt Ray sitting in for Rich Zioli, Talk Radio 1210 WPHT. We've got to hit the post on this one. Matt Ray sitting in, Talk Radio 1210 WPHT. We're taking your calls at 855-839-1210 on Twitter and on Facebook at Matt Ray Talk. Sitting in for Rich Zioli this afternoon. We're joined by Byron Henry right now. He's a legal expert and Supreme Court expert and appellate partner at Scheef Stone. 3 cases before the Supreme Court today before they hit the road for their summer vacation. And Byron, we just discussed the Texas abortion access law, a victory to supporters of abortion rights. I wanted to get into the conviction of former Virginia Governor Bob McDonnell. What specifically was the Supreme Court looking at in their 8-0 decision?
Well, this was a big case as well. It's overshadowed by the Texas abortion ruling that came down this morning. But basically, they were looking at federal prosecutors are charging former Governor McDonnell with taking a bribe. And in order to be liable for taking a bribe, the prosecutors had to demonstrate that he basically exchanged official action for some tangible good or tangible property, so money or property in response to official action. And those two words, official action, became the crux of the case and the Supreme Court's opinion, because the prosecutors took the position that official action can be anything from calling up someone at an agency and arranging a meeting, to introducing someone, to hosting someone in your house at the governor's mansion. And Governor McDonnell's lawyers and some others have taken the position that official action takes some official act by a governor, such as a veto or an appointment or the signing of a bill or something of that sort. It's more narrow. And so that was the dispute. And, of course, Governor McDonnell was convicted, and the official actions they used and the definition they used with the jury was the broader definition put forth by the federal prosecutors. And the Supreme Court today said that that's too broad, that official action for bribery purposes requires just what Governor McDonnell's attorneys argued, and that is a specific act that the governor is empowered to make, not meeting people, going to dinner with people, inviting people to the governor's mansion, arranging meetings and that kind of conduct. So it was a very big decision because, as you remember, our former Governor Rick Perry was charged with violating a variety of corruption statutes and abuse of power statutes down here in Texas, and the Court of Criminal Appeals down here in Texas made a similar ruling that the conduct alleged against then Governor Perry was not a crime, that it was basically the way politics is done, and it didn't meet the narrow definition required to indict him in that case. So now it looks like Governor McDonnell is going to, at worst, have another trial, and at best, he's going to have an outright acquittal.
Yeah, the throwing out the conviction you mentioned there just now, it leaves the possibility that he can be retried, but that current conviction vacated. What are the odds that he's retried on this? If I'm not mistaken, he said, "Yeah, I accepted the gifts, but in no way did it impede my ability to lead. It had nothing to do with me governing the state."
Well, the problem is that the actions that were the quid pro quo for the gifts, supposedly, were arranging meetings and allowing a fundraiser to be held in the governor's mansion, things like that, which I don't think were disputed. The question is, are any of those things official acts? And the list that I read in the court's opinion that he was charged with, most of those actions would not be considered official actions under the Supreme Court's opinion today. So unless there are other acts that the prosecutors held back on or that they're aware of that are not in the Supreme Court's opinion, it doesn't look like there's any acts that he could be charged with that would fit within this Supreme Court's opinion. So my view is the substantial likelihood that he is acquitted and he will not be retried, but there is at least a small window of opportunity for the government to retry them, but they're going to have to come up with other actions on Governor McDonnell's part that are more than what was in the Supreme Court's opinion today, because the Supreme Court basically said that is not enough to sustain a bribery conviction.
The 8-0 decision, what does that do to future prosecutions, public officials for corruption?
Well, I mean, it still leaves the full breadth of the tools that the prosecution has. It just basically is the Supreme Court reeling prosecutors in from possible overreach under this statute, but they still have the entire panoply of federal and state laws to rely on, and of course the bribery statute. Basically, the Supreme Court is basically saying to the prosecutors that this is, just a bridge too far to prosecute someone for accepting gifts and then, introducing individuals to one another, important people that they need to know in order to get things done. And the court basically stopped short of saying that would be unconstitutional, but they did say that it raises constitutional concerns to subject government officials, such as state officials, to that kind of oversight by federal prosecutors.
And then the final case that they ruled on, a victory for domestic violence advocacy groups, yeah? Certainly. I mean, it was a very narrow issue in this case. Basically, two men that had been
convicted of domestic violence, misdemeanor domestic violence, but it was a reckless mens rea, which means you could prove that they committed domestic violence without proving they intentionally committed it. And the real question for the court was the federal statute that prohibits crimes of people that have been convicted of crimes of violence from possessing a firearm. Did a domestic violence conviction that did not require intent qualify as a crime of violence? And the court in this case says that the recklessness mens rea does rise to the level of a crime of violence for purposes of the federal statute. And so those that are convicted of domestic violence, whether it's reckless or intentional, are going to be subject to the ban on owning or possessing firearms under federal law.
What was the argument, the 6-2, the 2, what was the argument there?
Well, basically the argument on the other side is you're getting down to the bottom of the totem pole of criminal charges when you talk about things that can be proven with recklessness or gross negligence. In other words, those are criminal charges that carry very light sentences and can be sustained even if you can prove you didn't intend to do it, but it was basically gross negligence. It wasn't even intentional. And so the court's basically saying, or the other argument is that you're talking about a constitutional right here that is going to be taken away because someone basically committed a bad accident occurred. Unintentional conduct should never result in the denial of constitutional rights. And so that argument had some force, but not enough force to carry a majority. And I think with the domestic violence movement and all the headlines dealing with the domestic violence in the media these days, I think the result that any conviction for domestic violence prohibits someone from owning a firearm is probably consistent with the domestic violence rubric that we live in today.
Sure. Glad to see there weren't any ties.
Yeah, there could have been, but no, there were no ties today.
Byron Henry joins us from time to time here on WPHT. He's a legal expert and Supreme Court expert, also an appellate partner at Scheef Stone. He's out in Texas where they had that ruling on the Texas abortion law there. Byron, we appreciate your time as always. Thanks so much.
You're welcome. My pleasure.